Good afternoon, everybody. My name is Ari Rothman. I'm an attorney here at Venable, and this is...
Shaheen Rothermel. I'm also an attorney here at Venable's Ad Law Group.
And we specialize in advertising and marketing matters, as you might have gathered. Today we're going to talk about developments in automatic renewal laws. We started off with a quick agenda, some background about it, what the applicable rules, laws, and regulations are, the general requirements, and what we're seeing in the space in terms of how these rules are enforced. Just focusing on the specific type of subscription-based offers that we're talking about, it's the negative option marketing. That's really what we're focusing on here. And that we're defining as the customer's silence or failure to take an affirmative action to reject goods or services or to cancel the agreement. And that, the seller interprets that as an acceptance of the offer. Basically, when the consumer signs up for something, gets charged every month, and doesn't do anything to cancel it. Examples of that are membership clubs, automatic renewal programs, subscription programs, trial offers. Those are the salient examples of what we're covering today.
And we use the term negative option programs to cover all of those. Some people believe negative option programs are limited to introductory trial programs, and in some laws they are defined differently, but for the purposes of our discussion today, we'll call them negative option programs.
And so what we counsel our clients to do is think about who your audiences are whenever you are developing these kinds of programs or any other kind of advertising for that matter. You've got consumers. It's sometimes B2B, so business to business can be considered consumers under certain state laws. Law enforcement, FTC, state attorney generals, for example, class action attorneys, and competitors. Those are all looking at what you're doing for different reasons. Consumers because they might want to engage you, law enforcement because they want to make sure you're complying with the law, class action attorneys, they say it's because they want to make sure you're complying with the law, but they're probably also looking to see how successful you are to trip you up and send demand letters out and lawsuits. And competitors, just to see if they could push the envelope like their competitors are, they're also your audience. So that's who you're targeting all of them at the same time here. The overarching principles we have for the negative option offers are to disclose the charges. We've given you some bullet points there. What is being charged, when it's being charged, and for what. You need to disclose those things before obtaining payment information and send a confirmation after the transaction is complete. You obviously should have systems that maintain that information to show the confirmations, for example, are going out and in. When you're obtaining the payment information, maintain evidence of the disclosures. Obtaining consent and maintaining evidence of consent are both important, and making it easy to cancel. Those are sort of the three overarching principles that anybody engaged in negative option offers should bear in mind. Then in terms of and by the way, I should have mentioned this at the beginning, there's more content in these slides than we can cover. We can't possibly cover every bullet. We'll push these out to anybody who wants them at the end and obviously take questions. But if we're skipping over things, it's just a timing issue, and we don't want to bore everybody issue rather than, they're not important. All of this is important. So in terms of the applicable laws, you've got the federal laws and the state laws. Those are all listed out there. The first one we're going to cover is the Federal Restore Online Shoppers Confidence Act, which is on the next slide. And that one requires online merchants selling a product or service on a negative option basis too. And there's a bunch of requirements. If we could go to the next one. And then those are the salient requirements. Provide a text that clearly and conspicuously discloses all material terms of the transaction before obtaining the consumer's billing information, obtaining the consumer's express informed consent before charging the consumer's credit card, debit card, bank account, or other financial account, and provide simple mechanisms for the consumer to stop the recurring charges. In other words, that's cancellation from being placed on the consumer's credit card, debit card, bank account, or other financial account. I'll kick it over to Shaheen to go through. This is important. The negative option rule, because this is something that is evolving right now. and sort of like the headline for the current development. Sheen, do you want to cover this one?
Sure. So the negative option rule is a rule that is pretty old, that's been in place with the FTC, and it's in a state of flux right now because in the end of September, the FTC issued an advance notice of proposed rulemaking and a request for comments. So right now, businesses have the opportunity to get involved in what could potentially be the expansion of the negative option rule or other changes to the negative option rule. Right now, it's limited to pre-notification plans, which are essentially book of the month plans or other programs where the seller sends a notice of something that will be shipped out in the future and will charge for that product if the consumer takes no action to decline the offer. So the negative option, because the consumer takes no action, they'll be charged. This doesn't include the general continuity or automatic renewal programs we think of, like a subscription box program, or even a free-to-pay or nominal-to-pay program where the trial period rolls into an automatic renewal program. The FTC, so under the current negative option rule, there are certain disclosure requirements and other procedural technical requirements in terms of time periods in which introductory notices and the merchandise must be sent by, periodic announcements, instructions for rejecting the merchandise in advance, honoring requests. These go back again to the same principles that Ari talked about in the beginning. However, the FTC has issued this notice that might change those requirements. It's identified a few problems. The one that I'm sure most of us are thinking is that this is such a narrow rule. It only applies to this small subset of what we consider in the broader negative option plans and programs. The FTC's noticed that it's receiving thousands of consumer complaints per year about negative option marketing generally. So not just these pre-notification plans, but negative option marketing generally, going back to subscription program, auto renewal programs, and free-to-pay conversions. And the FTC's noticed, again, that the rule doesn't cover the vast majority of those programs. The FTC has noticed, however, and something that we have advocated on behalf of our clients when we're talking to the FTC about these rules, is that there's other frameworks that do apply to the broader programs. So the Restore Online Shoppers Confidence Act, which applies to online transactions, and the telemarketing sales rule, which applies to telemarketing or telephone transactions. But the FTC has said that these patchwork of laws, they're too different. They don't subsume everything. And so it's not, the FTC believes that something needs to change for the negative option rule to address those. And to that end, the FTC has requested comments from the industry and groups on the rule. And they've issued a number of questions, but I've put only a few of them up here. The important ones are what modifications the FTC should make to the rule, whether there's a need for new regulatory provisions within the rule, including whether it should be expanded to other negative option programs that aren't currently covered. One thought that I thought was really interesting was what are the costs of compliance that the rule is imposed on businesses, and what would the cost of compliance be if the rules expanded? The FTC has also talked about imposing additional technical requirements that could be imposed on the types of broader negative option programs. So the rule could potentially really expand in reach after the FTC undergoes this notice and rulemaking procedure.
And the comment deadline is December 2nd, 2019. There's still time left. Even though those are the questions that Shaheen outlined, there are a few more. I mean, you can use this as an opportunity to basically say whatever you want within reason. And if you have any questions about that, reach out to us offline. But this is definitely an opportunity where comments will be considered and heard, and the window is narrowing here. You've got about a month left. So for those of you who are interested in this and think it might materially affect your business, I would jump on it. The telemarketing sales rule, TSR, is another applicable rule here. We talk about that a lot in our practice. It applies to telemarketing and sales made on the phone. And if you're engaging in negative option offers, the TSR will require, I mean, it requires for things other than the TSR, right, Shaheen? But focusing it on here, the nature of the goods or services, the fact that the consumer's account will be charged unless he or she takes affirmative action, such as counseling to avoid the charge, the dates on which the charges will be submitted for payment, and the specific steps the customer must take to avoid the charges. If you're doing that through the phone, you're wise to have scripts that are maintained and followed in writing on these points. I would obtain from the customer his or her express agreement to be charged for the goods or services and to be charged using the account number. Again, you got to be careful with what you record in terms of credit card numbers, but the substance of it is you want to make sure you've got proof that the consumer is consented to doing the things that you're telling them you're going to do and that you actually are going to do. There's also some record keeping requirements. Those are pretty technical, but we can get into that, offline, I think.
Right. And the other thing about the telemarketing sales rules, a lot of our clients have companies that are really internet-based, and they only offer customer service over the telephone. But sometimes those customer service scripts allow saves or downsells in some instances, or let people skip a month of their subscription. And then people are collecting information and consummating other sales on the telephone. So a lot of times our clients say, well, the telemarketing sales rule doesn't apply to me. We're an online merchant. But the FTC and regulators do take a broader stance on that. So you might be subject to it even if you don't think that you are.
Another statute that most of you are going to be subject to is the Electronic Funds Transfer Act. It's a federal statute. And it has specific requirements for debit cards, some confirmation requirements, notices of material changes, and record-keeping requirements. It's a technical statute. We could spend a whole day on that alone. Class action lawyers like it because they believe that it's easy to get a class certified there. But again, those are some technical requirements as well. They're sort of in line with the TSR.
That's true.
As well. That you want to keep in mind, another body of law there. Sheen, do you want to talk about how the FTC Act applies to this?
Sure. So the FTC Act is really the catch-all act of the Federal Trade Commission that generally prohibits unfair and deceptive acts and practices relative to consumer transactions. The FTC, in the context of negative option offers, has highlighted specific things that it believes are deceptive or unfair. So the disclosing the material terms of the offer before you obtain consent. The disclosures have to be clear. Consumers have to see those disclosures, and that a marketer has to obtain the consent to the offers. And I think a really big one, too, is that a marketer must not impede the ability of a consumer to cancel. So if somebody asks to cancel, to let them cancel. Companies who don't do that they open the potential for the FTC challenging that conduct as deceptive. What I also thought was interesting is that the FTC also thinks that billing consumers without their consent is an unfair act under the FTC Act. So they've sort of bifurcated what they think are the two buckets of their authority into these things, but really it goes back again to the same principles.
Well, on the cancellation piece, on that last bullet, about non-impeding effective operation of cancellation procedures. Bottom line is those are the people that are most likely to complain and cause you problems anyway. So you want to know who those people are, and you don't want to have anything to do with them as quickly as possible, because those are the ones that are going to be causing you problems. And that's where you got to be careful with the saves and the downsells. So, my rule of thumb is if they don't want it and they tell you they don't want it, then cancel them and move on. But every client has their own risk tolerance on it.
And one thing I did want to say, because I know that we have some companies on the phone that are membership organizations like trade associations and professional societies that have multi-year automatic renewal provisions. Sometimes they think that the FTC Act doesn't apply to them. But there was a Supreme Court case a number of years ago in which the Supreme Court held that the FTC does have jurisdiction over those types of organizations, even though they're generally considered nonprofit corporations.
State law requirements.
So the state laws impose requirements above and beyond the FTC Act and ROSCA. I think we generally agree that FTC and ROSCA are they're not very clearly defined. They don't have a lot of technical requirements, and we get our guidance on how to comply with those statutes from regulatory enforcement actions. In other words, what the FTC tells companies to do in their settlement decrees. We know that that's what the FTC expects because they're saying this is how clear and conspicuous, for example, is defined within a settlement. However, state laws, we're seeing a trend of more and more states that are passing automatic renewal laws. And in addition to having those broad principles that we've been talking about throughout, they have a lot of technical requirements. So, for example, defining clear and conspicuous. California has been the law that we've looked to. We say in larger type in the surrounding text or in contrasting type font to the text that's the same size, set off from the surrounding text. And it has to be in visual proximity to the request for consent in some states. And in other states, there's actually requirements as to font type, so minimum size font for specific types of programs. Disclosures have to be in bold in certain states. There's additional requirements for consent in particular with regard to some states like Vermont that requires consent be obtained separately from consent to other requirements. And we'll talk about these a little bit more. But, renewal reminders with very specific disclosures, the ways that you permit people to cancel, additional notice and consent requirements if you have a trial program. And as you can see here below, these are enforced by state AGs, class action plaintiffs, and in the case of California, the district attorneys. California actually has an automatic renewal task force. I guess they call it CART for short. And they are incredibly active. We see numerous multi-million-dollar settlements coming out of California every year.
So although this is not law, a lot of our clients can and should treat it as such. The brand rules, MasterCard and Visa, have also been imposing some rules here and requirements. So effective this past April, MasterCard passed some rules that apply to specific non-face-to-face transactions for subscriptions to receive physical products, cosmetics, healthcare products, and vitamins. For those of you that are super technical on this, it applies to one merchant category code specifically under MasterCard. If you have that merchant category code, then you must be registered with MasterCard. Your acquiring bank has to verify compliance with applicable laws and regulations. The trial offers, and this is unique, once the trial period expires, you have to provide the disclosures again and then get the consumer to opt in again. So you actually have to get consent twice and provide a direct link to online cancellation procedures. So that's pretty intense. That's new. That's happening and has caused some people with that merchant category code to just stop processing. Visa is coming up next. That's going to be effective this coming April, and it's more expansive than MasterCard. It's going to apply to the physical and digital products. You must electronically send the cardholder at the time of enrollment the terms of conditions, even if the consumer is not being billed at the time. The merchant will be required to provide an easy way to cancel, regardless of how they interacted with the merchant. It has to be online, by the way. And there's additional notice requirements, including specific information to be provided on the transaction receipts. That also overlaps with FDF. So Visa and MasterCard actually get a lot of what they're doing from the laws that we just discussed. They're also obviously doing it to protect the banks and the brands from merchant issues surrounding negative option offers.
And Visa has actually said in their announcement that they're going to be doing some secret shopping. So they're going to be enforcing. And so that really underpins the idea that both merchants as well as processors and ISOs should be looking carefully at both the new card brand rules in addition to the laws, because Visa and MasterCard are saying that you need to comply with both their rules and applicable laws. So it's something to keep in mind when you're onboarding and ongoing monitoring of your merchants as well if you're a processor.
So then in terms of the general requirements, let's go right to the next slide. We made this sort of roadmap that sort of brings in all of the laws into this sort of organizational flow chart. And so we're going to walk through each of these right now, because this is how it would go from like the inception of the consumer interaction all the way through the end. So Shaheen, do you want to start with what the disclosure requirements are?
Sure.
We'll go from there.
So the first really requirement of all of the laws that we look at are you have to disclose. Disclose early, disclose often, disclose after. The disclosures that need to be provided will depend on state laws, but the general required disclosures are, first of all, that the subscription agreement or the negative option program is going to continue. That the mere fact that somebody will keep getting charged unless they do something. then you have to disclose the charge. What is being charged, and what are you charging people for? And this sounds really simple in concept, but when we're looking at offers, a lot of times it's not always clear. And when you're offering, let's say, a program that has multiple different features, it's important to look at those different features. What are material? When you have different pricing plans, what features are encompassed by different plans and how much those are being provided for, in addition to the term, the duration of the term, the length of the subscription term. Is it weekly? Is it monthly? Is it annually? In some cases, we have clients who want to have a minimum subscription term. So if you sign up in a specific program, they want you to be enrolled for 2 months, for example, because that's the minimum amount of time that it might take to really get all the benefits of a program. And that would be a minimum purchase obligation. And the last one that is really important that we'll talk about a little bit later is what is the cancellation policy that applies to the offer. And for trial offers, you also need to disclose that when the trial or promotional period ends, that pricing is going to change, when it's going to change, and the price that's going to be charged after the trial period ends. I think that, and we'll see a couple of examples later in the presentation, there's a lot of nuance when it comes to the wording of these disclosures, because a lot of times clients will come to us and say, this is so much, if we just disclose this, it's going to be 2 pages of text. But there are ways to provide those interactively or in ways that consumers can really see it while still complying with each of these points. In addition to the technical information and substance of what needs to be disclosed, state laws and regulators have mandated how things need to be disclosed. It needs to be in a clear and conspicuous manner, which goes back to the definition we talked about earlier. So in font that's larger or set apart from the surrounding font, and those font type and size requirements. It has to be disclosed before the consumer's billing information is obtained. So in some instances, what we see regulators saying that they actually want to see the disclosures appear before you even collect the consumer's billing information on the page, so that it appears above the submission box for consumers' payment information. Other times we've talked to regulators and they've said that, maybe if you put it right above the submit button, it's okay. But in all events, it needs to be in visual proximity to the request for offer if it's online. Going back to telephone sales, it needs to be in temporal or time proximity to the request for consent for offer. So in other words, sometimes you don't want to talk about the renewal provisions and disclosures early in the call, and then later on in the call say, well, do you agree? Because sometimes consumers won't know what they're agreeing to. The written disclosures of clear and conspicuous is defined here on the page. When it comes to oral disclosures, those really need to be made in a volume, so loud enough, slowly enough, and in a cadence that's readily audible and understandable, so no auctioneer voice. And as we have here, there are additional requirements under state laws concerning the minimum font size. I think it's 10 point in some states, bold language in other states. I have an example here. I mentioned earlier that the California district attorneys have an automatic renewal task force that's very active. One of their settlements was with eHarmony. I think that was either early this year or late last year. But in all events, eHarmony settled with multiple district attorneys in California under California's automatic renewal law. It settled for about $1.3 million. And as I mentioned earlier, what we do a lot of times to look and see what regulators think is sufficient is we look at the settlements, and then we go back and look at what companies are doing in light of those settlements to see what the regulators have really talked to. Because when we're going through and making a settlement with the district attorneys or with the FTC, a lot of times we will we'll go back and forth about what the actual online internet page should look like, and we negotiate with them about what we think that the way we think something should be disclosed or how it should be presented, and we go back and forth. So so as a general manner, and I'll caveat that we look and see what is being done after a settlement. The caveat to that, and I think Ari will talk about it a little bit later, is that the law does keep changing. What we've seen, and what we see a regulator say is sufficient, a court might not agree with. We've seen courts in California go different ways on the same issue. I remember even in 2017, we were talking about how quickly the area of law was changing and how sometimes the FTC in California don't necessarily agree with Illinois. So
and the other way around. Sometimes a regulator won't, regulatory body won't agree with a judge.
Right. And that's a lot of the times.
And so that's why those basic principles we outlined at the beginning are so important, because no matter whether you're talking to a regulator or you're talking to a judge, or you're talking to a class action attorney, if you can show that the consumers understood that what they were doing at the time they were doing it, what they were consenting to, that's going to get you 95% of the way there. And then if you have to deal with these technical requirements, you'll have to deal with these technical requirements. But, we like to think that they go for the low-hanging fruit here, but sometimes they don't.
Right. And so this is an example of a disclosure that eHarmony adopted after the settlement. You can see that it's got the plan terms there directly above the Subscribe Now button, and that some of the language there is bolded, but we'll let you read that on your own. The next requirement is the requirement that the companies obtain the affirmative, express, informed consent. And that's a bit of a mouthful because different states require different things. A lot of states require affirmative consent. The language express informed consent is from the federal rule. And so what regulators say is that express consent is affirmative or explicit agreement of the consumer to enroll in the program. It must be unambiguous. So on the telephone, somebody's saying, that's probably, that's something that a regulator could challenge as ambiguous, as opposed to yes. Silence would not be consent. Regulators say that informed consent consent is only informed after people receive all of the material disclosures. So in that respect, this sort of ties back into the disclosure requirement, because you can't really provide consent if you don't know what you're agreeing to. So you have to receive all the disclosures, and you have to receive them in the proper way in order to make informed consent. In order to actually agree to something, you have to know what you're agreeing to. So some state laws require affirmative consent as requiring people to take an affirmative action, opting into the automatic renewal provision. And in recent settlements, what we've seen is regulators requiring that companies have a distinct method. So a checkbox, a signature, like a radio button or something similar that the consumer has to affirmatively select before being able to be enrolled in the negative option. And the other portion of this that we see that regulators want is that people agree to the negative option terms, so those disclosures that I outlined, and no other portion of the offer. So, and Vermont has a similar law that you're agreeing to these terms and not any other portion. It's separate from any other contract. And what that means in practice is that you're not obtaining the same consent for negative option as you are, let's say, for telemarketing under the TCPA, or even for the terms and conditions in the privacy policy. The consent mechanism should be directly adjacent to the terms of the offer. The disclosures need to be in visual proximity to the consent mechanism, and a lot of times regulators want a checkbox directly next to the terms. And as I mentioned, they shouldn't be muddled with other disclosures. And here's an example of a disclosure or a checkbox that's immediately adjacent to a disclosure. And you can see here, this is actually JDate. And I realize that all of our examples, I think, most of our examples are actually dating websites, but there have been three challenges to those types of websites in the past year or so. So that's why I've chosen those examples, not because I'm trolling the website on dating websites. So here's an example of Spark Network's post-settlement website, and you can review that. Another consideration is for trial or promotional offers. So DC recently passed a law that requires the additional consent if there's a free trial of a term of 1 month or more where the contract automatically renews. And it requires that a company obtain separate consent to the trial than in addition to the ongoing purchase obligations of the subscription. And this mirrors a lot of the card brand rules, although the DC law says for a free trial, and it mandates for 1 month or more. So it's a little bit narrower than the card brand rule changes that Ari discussed earlier.
All right, so then Sheen covered what happens before and at the time of enrollment. As we alluded to, EFTA and the MasterCard rules and others require order confirmations right after the transaction is completed, and that the requirements are there. It has to be in writing, repeating the offer disclosures. And that, the offer disclosures are required in some states. The format depends on the state. And so depending on how big you are and where you're transacting business, you need to make sure that you are complying with all of the requirements in all of the applicable states. There's a requirement that the merchant send an acknowledgement in a manner that is capable of being retained by the consumer with specific offer terms, email, that doesn't have images that self-destruct, that sort of thing, need to be there. If the automatic renewal offer or continuous service offer includes a free gift or trial, then the merchant or business needs to disclose in the acknowledgement how to cancel and allow the consumer to cancel before the consumer pays for the goods or the services. And that needs to be clear and conspicuous in the order confirmation after the transaction is made, not just before.
Right, and that's been the subject of some challenges too, is that even though you sent an order confirmation, you had the disclosure of the terms, it wasn't clear and conspicuous in the order confirmation. So we see these challenges get really granular when people are taking action under the state statutes.
You need to hit them before and after. So then the renewal we're on the
cancellation mechanism.
Simple cancellation mechanism. That's right. So this is where you are allowing the consumers just to cancel as easily and as quickly as possible. That's the thumbnail rule there. You should provide a toll-free number, email address, postal address, or other cost-effective, timely, and easy-to-use mechanism that the consumer can use to cancel. Our advice would be give as many of those mechanisms as you can. So that way, if anybody ever challenges you about whether or not you had a simple cancellation mechanism or could be reached, you can say, look, I gave them my phone number, I gave them my postal address, I gave them an email address, I gave them a link. All of them were working at the time. And that should greatly minimize any issues as opposed to having just a toll-free number that might only be running from 9 to 5, Monday through Friday on a single time zone. Consumers who accept an automatic renewal offer must be allowed to cancel the offer online. And additional laws and rules require companies to provide a web link to permit online cancellation. These days, it should be online anyway. Mm-hmm. So again, I would do as many of these as you can because that'll put you in the best position, both because you'll hear from the people who don't want to hear from you, which you'll know, blacklist them or cancel them out or whatever it is. And second, in terms of ever having to defend yourself, you'll be able to show the regulator, class action attorney, whoever it is, even Visa and MasterCard, if you ever get matched or there's ever a fine or a monitoring program that's being imposed, you'll be able to show them, look, we had all these things at the time and whatever it is that they're complaining about was either an anomaly or incorrect.
Right, and one thing I wanted to say too is that the Visa regulations their advice is now for the new rules that the cancellation mechanism should be as easy as an unsubscribe link on an email. Something that regulators look at a lot when we're defending these challenges is things like hold times. If somebody calls in to a telephone cancellation number, how long are they on hold? How long is the average conversation with the customer service representative, whether or not they're on hold? Because regulators view that as an indicator of whether or not it's easy to cancel because maybe that cancellation request isn't being accepted.
Yeah, what questions are being asked by the operator? Are they germane to what's going on? Same thing if you're doing the link. I mean, even if you do a link, they're saying it has to be the same as unsubscribe for an email. You could still click a link, end up on a landing page, and then see a bunch of questions there that have nothing to do with anything. I mean, what the best rule of thumb is to make it as easy as possible to cancel. And we know our audience wants to save those cancellations as much as possible, but that's an issue that you've got to weigh. the risk and the benefit there.
Right.
You want to talk about renewal reminders?
Sure. So the renewal reminder notices are a bit more technical requirements. Certain states, and this is actually a broader requirement, so a lot of states require renewal notices for the longer term programs, which makes sense, right? So if you have a program that's a year-long program, people might not know that they're being charged, or they might just not remember if it's not a product or service that they use very often, if their card's only being hit once a year. So a lot of these statutes, and I want to say there's around 20, although I'm sure more are in the works, say that sometime between 45 and 60, I think in some states it's 90 days before either the automatic renewal date, the termination, or the cancellation deadline, the company needs to send its customer a notice that contains specific provisions about their about the program, about the charges, that the charges will, or that their subscription will automatically renew, what charges are going to be applied, how, if there are any changes, and generally that a cancellation mechanism being provided within that renewal reminder too.
Well, speaking of changes, is that me?
Yeah, that is you.
So material changes to the offer. If there are changes, you need to provide the current customers or consumers with a clear, conspicuous notice of the change and information regarding how to cancel, basically giving them a chance to opt out or cancel if there is a change. And that also has to be provided in a manner that is capable of being retained by the consumer. So not a fleeting, we shouldn't be doing text messages at all, probably for different reasons, but not a fleeting message, not something on some signal that'll self-destruct after however long. It needs to be something that needs to be kept. If a company charges a consumer a different amount than the amount stated in the original disclosures and confirmation notice, the company must send the consumer written notice with specific disclosures. I think that assumes that the price is always going to go up. But theoretically, I guess if it goes down, you would also need to provide that disclosure. And if the price or nature of the product or service changes, obtain the consent to the changes. So you got to get them to literally buy into the any price change or price increase.
Right. And one thing that we see a lot of, so we see these sort of technical requirements in state laws of notifying people of material changes to the offer. And then we see general state UDAP or mini FTC statutes. And what Ari and I have seen in the past are a price will change, it'll go up, and a company might send a notice or some sort of notice, but they don't obtain the consent to those changes. And what class action plaintiffs will often say is that, well, that's unfair, that's deceptive. Even though you sent me this fleeting notice, you never got my agreement to the change. And then we get into this argument about, what was the contract? Did we comply with this law? What type of consent needed to be obtained? So as a general matter, we do recommend that if you're changing the price, you're charging people more than you said you were charging them, get their consent. Depending on your program, there are ways to do that.
All right, so now how are these being enforced? We've given a couple of, I guess, dating site examples.
There'll be more.
Over here. What about the May 2019 settlement? That was a Rosca settlement, so do you want to cover this one?
Sure. That was with Earthbox. Earthbox had a monthly subscription box program where people could receive healthy snacks every month. So we see a lot of subscription box or of the month programs, and this was one of those. And in its complaint, the FTC alleged that they had failed to clearly and conspicuously disclose all the terms of the feature. So again, we see the failure to disclose being a reason that the FTC is going after a company, and that the company had allegedly failed to obtain the express informed consent to the feature before charging them. So here is, I've attached here the one of the exhibits to the FTC's complaint that it alleged was not a sufficient disclosure. And what I also thought was interesting about this on the next slide is, and I've zoomed in here and scrolled all the way down, so this isn't the way somebody would necessarily see the page as a consumer who's viewing it. But this is what was included in the FTC's complaint. as being insufficient for the for consent. And there it is. You see below the continue button is the language by by clicking continue. You acknowledge and agree to the EarthBot terms and conditions. Plans begin on the first of the month and automatically renew. You may cancel auto renew at any time before the end of your plan term. So that language was on the page and included in the FTC complaint. That was language that they challenged as being insufficient to disclose the terms of the offer and get consent. So it sort of shows you, I mean, it's there. The problem is most likely is that it wasn't above the continue button. There's no affirmative act by the consumer to expressly agree to those terms.
Doesn't say anything about the pricing. The font looks a little small. Got light gray against white background. So there are a few issues there. It's not the worst we've ever seen, but it's not as informed as the FTC would like it to be, or the state AGs for that matter.
That's right.
It's not as complete.
That's right. And the other thing about this is that the FTC oftentimes will challenge, font size and color. We see lighter font against a white background, and the FTC takes the position that when you're disclosing something, whether it's online or elsewhere, you have to be mindful that a lot of people can't see that well. And so the disclosures need to keep in mind and be catered to people who might be a little bit, maybe not completely visually impaired, but are a bit hard of seeing. The next case we have is another another dating site here, Match.com, and this was relatively recent, I think, actually. And the FTC challenged Match.com on a number of issues, only one of which was a negative option program on Match.com. So Match.com had a subscription program where you pay, to use their dating service. The FTC expressly took issue with the cancellation process. They said that Match.com's cancellation process was too hard, and that there were multiple save attempts, which is what we talked about a little bit earlier. Somebody who wanted to cancel would click on a button, and what Match did was they actually had a questionnaire asking people, why are you canceling? What are you looking for in a relationship? And really just doing a survey. And I know that that sometimes clients like to do this because they want to talk to their customers. They want to know what we can be doing better as a company to retain consumers, provide a product of value. But what the FTC said, and I think the problem in this case, was that it was too much. There were 6 or more screens. The cancellation flow was hard to find. And one of the problems was that people actually had thought that they'd canceled when they didn't, and they would end up with multiple renewals. And this is very similar to the FTC's complaint against Adore Me. And in the Adore Me case, which was back in 2018, that was a company that sold underwear and pajamas on a monthly basis to consumers. And the crux of the FTC's case there, in addition to disclosure and consent, was the cancellation mechanism. And in that case, there was a drawn-out cancellation process, according to the FTC, where there was like a 5-question membership quiz, and customers who called in to cancel had an average of an 11 to 32-minute wait time. So those are 2 examples that are relatively recent where the FTC is targeting companies for their cancellation mechanism. And here's an example of a disclosure that the FTC said was insufficient. I'm not going to read all of it, but this was provided using an IVR, so not a live person, but an interactive voice response asking people to press 1 or 2. So when people called in and they wanted to complete they wanted to receive a trial of this product, this IVR script would read the offer details that are pretty condensed there. The FTC took issue with this for a number of reasons, and one of which I think is really interesting, was that it wasn't IVR. It wasn't a live person. So as a result of it being an IVR, as a result of it, a person not being able to get another live person on the phone, the consumer wasn't able to ask the script to stop, rewind, repeat. I don't understand. Can you explain? And so the FTC said the disclosure made over the telephone in this case was insufficient. and that the only way that people could actually have the details repeated to them was by calling back and listening to it again. And there wasn't even an option for people, if they wanted to push 0 and talk to somebody, to get a live person here. Some other issues that the FTC said here was that it failed to disclose that people were required to take an action in order to stop the charges. It didn't disclose what the action was. It didn't specify when the trial period ended. And at the end there, the question is, do you agree to start your free trial? So the question that was being asked wasn't, do you agree to these automatic renewal terms? Do you agree to be charged on an ongoing basis on these terms? It was, do you agree to start your free trial? And the FTC said that, no, that's not asking for consent to the auto renewal terms. That's asking for consent to something different.
All right, state law enforcement actions. We have a list here for you to look at on the next slide there. The California Automatic Renewal Task Force, that's something that Shaheen mentioned earlier. These are just examples. We know there are more, but these are examples, some big names: Dropbox, J2 Global, Adore Me, eHarmony, Spark Networks, and Stamps.com. Are some of them. So those are, big names in California. New York Attorney General, there's a New York AG case against Adore Me, and a multi-state action against SiriusXM. Maybe we could take a look at the Dropbox case there. So that was filed in Northern California outside of San Francisco and Alameda, and the district attorneys of San Francisco, Sonoma, and San Diego joined it. In that case, there were alleged violations of California law by failing to present automatic renewal offer terms in a clear and conspicuous manner before the purchasing agreement was fulfilled in visual proximity to the request for consent. There were also some other alleged unfair and deceptive or misleading acts as well relative to Dropbox Pro, which was intended for business use and not personal use. Dropbox settled the case. There was a payment of a $500,000 restitution fund and $1.7 million in civil penalties, which that's actually a lot.
The California auto renewal, they go for the millions. I mean, see, I think the Earthbox settlement was maybe $200,000. I mean, the FTC settlements are monetary wise, it's lower than the automatic renewal task force.
Well, yeah, and they also fund their offices with.
That's exactly right.
So they're looking at it from that perspective. I mean, I don't know if they'll ever admit it, but that's really what's going on there. That's a big number from a big company.
And I did want to mention, too, in Dropbox and also the J2 Global case that was on the last slide, it's interesting because a lot of times we have clients that do B2B products, so their consumer might be a business, and we even see that consumers are defined differently in different state laws, but this is an example, and so is the J2 Global case, where here's a product that's arguably being sold to businesses, but the automatic renewal law is being applied to it anyways.
Okay, another dating site, kind of, King versus Bumble. Mm-hmm. This is a class action, and this was a challenge to a specific part of Bumble's website called the Boost program. And what got Bumble into trouble on this is that Bumble failed to disclose the mandatory automatic renewal offer terms before California consumers purchased their subscriptions to Bumble Boost. Bumble did not obtain the consent because there was no mechanism that required California consumers to affirmatively consent to the automatic renewal terms. And according to the class action, Bumble failed to provide California consumers with an acknowledgement that satisfies any of the requirements of California law. I think we gave an example there on the right-hand side of the acknowledgement there, and that was not sufficient.
That's right. I mean, yeah.
It wasn't.
Yeah, there's not much in there about the auto renewal terms, and sometimes people just don't, if you're not aware of the law, you might just not, you might leave out these technical requirements, and that's exactly what class action attorneys are looking for.
So here there was evidence of a confirmation that just didn't even come close to what was required. I'm wondering why they did it to begin with, but I guess that's for Bumble to answers at some point. We have Hall versus Time Inc. That's a challenge to a magazine subscription program, which has been around forever. The allegation there is that Time did not clearly and conspicuously disclose the material terms of the offer that was there at the time. Now, the court granted a motion to dismiss and found that the defendants presented plaintiff with the automatic renewal terms in a clear and conspicuous manner. And I think the specific points were when plaintiff first saw the subscription offer on her social media, that offer was coupled by a notice clearly stating that all magazine subscription programs will automatically renew annually. Pretty clear messaging there. And then another notice was placed directly above the checkout button, which plaintiff clicked to proceed with her subscription. There's an image of it. You should see it on the right-hand side there. All magazine subscriptions will automatically renew annually. Check out now. There's no checkbox, which is interesting, but you still have like black against. I mean, on this one, there's no checkbox.
Well, yeah, we were going to talk about the Time case, so that one is still going on there. So the court granted the motion to dismiss in that case, and you've got the disclosure right up there that the court said was enough. And what the court really looked at there was that it really said that, you know, the plaintiff saw this. The plaintiff knew. It automatically renewed. You have no way of arguing that you didn't know that it automatically renewed. So what the court looked at there was that language was directly above the submit order button.
It's in yellow, black against black. Yeah, it's set apart, black. I mean, it almost takes up half the page or half of this screen. So that looks pretty strong to me. And by the way, a lot of judges won't dismiss these things that early.
That's right.
But if you've got it nailed down, especially if you're in federal court, there are some judges that are not afraid to toss it if you've got the goods to toss it. But you got to be strong, and this is pretty strong. Again, even without a checkbox, we would recommend a checkbox, but there are ways to get around it, and Time did it. So here you have it. But just be careful because this, sort of roll the dice. Anytime you don't ever know what judge you're going to get, and another judge could easily have sent this to the jury to decide whether or not this disclosure was adequate.
That's exactly right. And we've seen cases where the judge will look at something that's as simple as, well, you didn't say when a consumer had to cancel by in order to avoid the charges. So we'll see, and that was enough to state a claim. That was enough for the plaintiff to go further in their case. And that's something, those small things and those details are things that, even with this Time victory, people need to think about, because let's say you have a process requirement cancellation-wise where if somebody cancels their service 10 minutes before the charge is scheduled to hit their card, we don't have a way we can't stop that charge in 10 minutes just as a process issue within our company. Or you need to cancel 2 days ahead to avoid getting shipped to the next product. If you have a product that's being shipped within a certain time and cards are being hit at that time. So it's these sort of procedural issues that companies need to think about when they're engaging in their subscription programs and thinking about how they're disclosing that to their consumers. And one thing, Ari, I was hoping you could talk about, and we talked about this a little bit yesterday, was arbitration clauses. Because one thing we've seen is arbitration clauses actually being enforced. I think there were 2 cases involving automatic renewals this year alone where the courts compelled arbitration.
Yeah, I mean, the default rule is to try and bind your customers to a class action waiver or arbitration, or actually I'm involved in one right now where there's no arbitration provision, but just a class action waiver, which I thought Venable we didn't draft it for that client, but now it's on our desk and we're trying to deal with it. And it's actually interesting because a lot of judges and attorney generals, they don't like arbitration provisions. They don't like taking away any consumer's rights, like going to court, and doing it as a class action. But other judges will enforce them. And so we still recommend putting them in. Having said that, we recommend making them as consumer friendly as possible. They have to be clear, conspicuous. You got to show that the consumer agreed to it. You got to show what the terms were. And that way, when you go into the judge, you can say, look, this is how we disclosed it. It was there. They agreed to it. It's a contract. They manifested their assent to it. And they had an opportunity to opt out, whatever the situation is. But also consider just putting in a class action waiver and not making them go to arbitration. Because then you don't have to have, the argument about we're taking away a plaintiff's right to go to court. We're giving them the right to go to court. We're just saying they can't represent other people when they go to court, which is what a class action is. And I think that's a unique way of addressing this problem, too. And that sort of raises the final closing point I have, which is, look, we went through a bunch of relatively general, some specific examples of how different people have done different things given this very specific body of law with very specific requirements. Each offer funnel is different. Each way it's presented is different. The terms are each different. Like, we haven't seen one offer to the next that's exactly the same. And so you have to take what you have and sort of take this general body of law and make it work for you and go from there. We're happy to answer any questions about that or anything else about this presentation. You have our contact information there on the last screen. And I think with that, we are about right on time. And we'd like to thank everybody for joining us.